Welcome back. Attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Today we're focusing on real estate, specifically the difference between legal ownership and equitable or beneficial ownership of property. The distinction between legal and equitable ownership is foundational to property law and estate planning. These concepts arise primarily in the realm of trusts, but they can be applicable in other cases as well. And remember that equitable and beneficial ownership are the same thing in this context, so for brevity, I'm going to simply say beneficial ownership from here on. Let's dive in. Firstly, let's get the definitions of legal and beneficial ownership out of the way so we're all on the same page. Legal ownership refers to the formal legal title to property. The legal owner has the right to possession of the property, saying it's mine, the power to transfer the property, and the right to enforce property rights in court, kicking somebody out of the house, for example. However, the legal owner might not necessarily have the right to enjoy the benefits or fruits of the property. This brings us to beneficial ownership. Beneficial ownership refers to the right to enjoy the benefits or fruits of the property. The beneficial owner is the true owner in terms of economic benefits. For example, they may have the right to income produced by the property or the right to its use. To break it down to more simple concepts, legal owners get all the management rights that come with owning property, while beneficial owners get all the economic or fun benefits of owning property. Typically, you're going to be both legal and beneficial owner of your property, to where there is a distinction between the two, but not a difference in practice. You may be wondering though, what's the point of having the distinction, and why would you want to separate them in the first place? So let's go there next. But first, I would ask that you provide us with the beneficial interest of your like and subscription if you find this helpful. Don't worry though, they're still your legal property, so there's nothing I can do to take it away. Gosh, that's terrible. Why would you let me say that? Of course, with this primarily being an estate planning channel, you didn't think you were going to get away without me mentioning trusts, now did you? It just so happens that a trust is a prime example of where we have this distinction between legal and beneficial title, and it actually plays out in practice. In the context of a trust, there is a division between these two types of ownership. The trustee holds the legal title to the trust property. They have the responsibility to manage the property for the benefit of the beneficiaries, while the beneficiary has the equitable or beneficial interest in the trust property. They are entitled to benefit from the property, such as receiving income or using the property, based on the terms set forth in the trust. Let's look at an example where we'll start simple before making it complex. This example is going to be how most of us interact with trust and legal and beneficial ownership. We have Mary, who owns her home and creates a trust to hold this home so she can pass it on to her daughter, Darla, probate-free. During Mary's lifetime, she is the trustee or manager of her own trust and the lifetime beneficiary of the trust. This means that Mary has legal ownership of the property as trustee of her trust, and that she has beneficial ownership in that the trust obligates the trustee to manage the property for the benefit of the beneficiary, Mary. And to be clear, Mary did not lose her property by putting it into a trust, since she would also be the trustor of this trust and therefore control the terms, such as who the trustee and the beneficiary are. Things change a little after Mary's passing because she is no longer able to operate as trustee, and her daughter Darla is now the beneficiary of the trust. However, instead of simply saying the trust is to distribute the property to the daughter outright, let's make it more complicated and say that Mary's trust requires her house to remain in trust following her death, and for the rental income to be distributed to her daughter Darla in quarterly installments, with Mary's brother Bill as trustee. In this scenario, Bill as trustee now has legal title to the rental property, and thus he is responsible for managing it, perhaps dealing with tenants, maintenance, and etc. Darla is the beneficial owner. She doesn't manage the property, but she receives the rental income. Of course, Bill is likely entitled to a fee for his services, but that's trustee compensation, something I've talked about before. Now I know what you're probably thinking. Okay, Andrew, that's great and all, but why does this matter? Well, I'm glad you asked, because your mind is in the right place. There are a few cases where the distinction between legal and beneficial ownership matters, so I'll cover 3 big ones. The first up is, drumroll please, lawsuits. Yay. But in all seriousness, taking our example, if Darla thought Bill was mismanaging the property, not collecting rent, not keeping up with the maintenance, skimming money off the top, what have you, then Darla has standing to bring a lawsuit against Bill because she has an interest in the property. She is the beneficial owner of the property. Darla's friend Fran can't bring a suit against Bill because she has no stake in the game. She has no standing. So being a beneficial owner of property gives one standing to enforce rights related to said property. The second big reason to separate legal and beneficial ownership is for creditor protection or to protect the beneficiary from themselves. Now, what does this mean, you might ask? I've talked about this in detail in the context of special needs trusts, so I won't go into too much detail here. To quickly relate to what we're discussing here, if we have a beneficiary who cannot receive a lump sum inheritance either because they have a creditor issue or they're on some sort of public benefit, or they simply can't manage the property themselves for one reason or another, then a common strategy is to only give them a beneficial interest in the property in question, but not legal title. Using our example, Darla has creditors. Those creditors will not be able to collect against the house as it's not something that Darla has legal ownership of. However, once the rental income hits her hands, it's fair game to collect against. Same concept with public benefit. It's not Darla's, so the program can't count the house against her. And finally, let's say Darla had a drug or simply a spending problem. Not letting Darla manage the property directly could be used to protect Darla from herself and require her to learn to budget her money. Jumping from there, we have the last example where we see legal and beneficial ownership separated, which is where parents simply want to keep property in the family, whether because the kids aren't mature enough or the parents just want to glue the family together. By placing assets in trust, the parents can ensure their children benefit from the assets without giving them direct control. You see this with family homes that have been in the family for generations or family businesses. To bring it all together, the distinction between legal and equitable or beneficial ownership allows for nuanced control and benefit distribution strategies, especially in estate planning. It's how wealthy people create dynasties and how the rest of us can create a legacy and generational wealth for our family. I hope this video was insightful. I'm attorney Andrew Bethel, guiding you to make the best decisions for you and your loved ones. Drop a comment below if you have any questions. Don't forget to like and subscribe if you found this video helpful, and check out our other great videos. Stay informed, and I'll see you next time.